Hi, I'm Roger Levy.
I'm John Gray and welcome to Home Truths.
The penalties have to be commensurate with the magnitude of the miscalculation, as it were.
Well, Roger, I've had a talk with Professor Kim Lovegrove, and as you well know, he's world renowned in the area of building regulatory regimes, and he was one of the founders of the International Building Quality Centre, and they have a model regulatory regime, which I think is what New Zealand should be adopting. We're very lucky to have had an opportunity to speak with him, because he's also been engaged by the New Zealand government to consult on the proposed regulatory change.
Okay.
Kim, you're very involved with the IBQC, the International Building Quality Centre, and you've published various papers around the regulatory regime. So you have an international perspective on building controls around the world. How does New Zealand shape up in terms of the competencies of builders and other experts involved in the construction of a home?
The traditional competency criteria here don't stack up terribly well relative to other jurisdictions. I was recently doing something for the World Bank in Malaysia, and I was just looking at the Twin Towers, and I just complimented them on an extraordinary technological monument there. And I said, you must have some remarkable people here, some exceptional artisans. And they said, yes, our builders are graded. There's 7 categories, and only the highest category can do the projects of state significance or these architectural monuments. And I was just blown away. 7 categories. And when I look at best practice jurisdictions, I ask the question, has there been a systemic failure? And jurisdictions where there haven't been systemic failures that come to mind are Singapore and Germany. And these are jurisdictions that have very robust levels of competency. For instance, in Germany, there's a thing called the proof engineer. They're called the third set of eyes. And in a lot of their buildings, you submit your drawings to the council, and then the council will send the drawings on to the proof engineer, who's a highly qualified and venerated engineer. And the engineer will review the drawings, then come up with recommendations and remit them back to the council. And then the council will go back to the applicant and say, you need to do this, that, and the other. So you've got many, many exemplar jurisdictions that have very high levels of competency. I'm fascinated in New Zealand when I look at the LBPs. You've got your carpenters, your roofers, your brick and block laying and external plastering actors that are LBPs. It's a very different approach to registration and competencies in the likes of Victoria, in the sense that the head contractors, the principal actors that the owner will engage with, namely the head contractor, the builder, the architect, the engineer, they're the ones that are the licensed building practitioners, whereas the trade contractors in jurisdictions like Victoria are not required to be registered. They'd all fit within the fold of responsibility of the head contractor, the builder. So there are a couple of examples of where I think New Zealand is quite not unique, but unusual.
So you touched on the head contractor, so the building company as such. Are they covered under the licensed building practitioner regime?
Builders in Victoria have to be registered. Yes.
So the building company is registered, or the individual?
The company, yes, but the company can only be registered regardless of whether it's a building surveying company, an engineering company, if there is not less than one director who is a registered building practitioner as a natural person, a thing that bleeds.
Yes.
Yeah. And where do we get that from? When I was heavily involved in generating the legislation over there in Victoria, and a thing called the National Model Building Act, I use the lawyer example. A law firm has to have at least one principal who's a registered lawyer with a practicing certificate. So we use that template.
In relation to competencies, we're concerned that the current thrust from our government is to this broad sweeping change to the Building Act. But from our perspective, there doesn't appear to be any real focus on quality. Your IBQC documents talk about appropriately weighted civil and potentially criminal consequences for those practitioners who get it wrong.
In jurisdictions like Japan, the building standard law has got a criminal punitive element to it. Even the Building Act, Victoria, carrying out work without a building permit can attract criminal censure. The IBQC is about to publish an International Model Building Act. It'll be the first one ever. And what we've done is, in terms of penalties for problematic conduct, we've stated that the punishment must be based upon a rationale that can calibrate the severity of the offence with the severity of the punishment. A penalty will not be effective unless it can impact upon lifestyle of the recalcitrant. So if it's seriously egregious conduct, there has to be very serious censure. That's number one. Number two, you've got to have the critical mass of enforcement operationalisation so that you can actually enforce what the legislation allows you to do. And if you don't have that critical mass, then it's not going to be an effective disciplinary or oversight ecology.
One of the standout cases in New Zealand is the Canterbury television building that was destroyed in the Canterbury earthquakes. And it turns out, of course, that the engineer was found to have designed a building that he was not qualified to do. And of course the police were very torn because they didn't have any basis under which they could bring criminal charges against him, even though there was significant loss of life. So having those, or that ability within a Building Act regulatory regime, does that create a pathway to deal with someone who has done something like that?
Yes, it does, and that's what Japan's done with its building standard law. Some context. I've been deployed on 2 occasions by the Japanese government to participate in think tanks when they've overhauled their the equivalent of their Building Act, their building standard law. And the last time was about 2012, and the backdrop was that an engineer had generated very problematic engineering drawings, and the culmination of that was there were a number of buildings that were identified as not being fit for purpose. So it created quite a storm of controversy. There were no deaths, but he was prosecuted, and very sadly his wife leapt off a high story and died. Such was the loss of face. I think the general comment would be the higher the level of competency, the greater confidence one will have in a successful outcome.
So Roger, having viewed that first portion of the interview, what did you make of that?
Yeah, the extent of their licensing was interesting. How, when he talks about what comes under the licensing regime over there versus here.
Yes, I mean, we have licensed building practitioners which covers carpentry and foundations and what have you. But the architects and engineers are not necessarily under that licensing regime because they're controlled by their own professional organisations. And why wouldn't the engineers and architects be brought into the licensed building practitioner regime so that if they err, they can be dealt with by the licensed practitioner board?
Yeah, and that's the independent. That having their own bodies isn't necessarily a fully independent situation to be dealing with. Whereas if they came in under the licensed building practitioner regime, you would have that level of independence that comes with that regime.
Yes. We would argue, of course, that everyone from the top to the bottom needs to be licensed, including the directors of some of these companies.
There's just nothing really focused on improving the quality, which then addresses all these other issues of liability and
I mean, if
insurance.
If you get it right, you're not exposed to liability. You know? So that's the starting point, and that's, at the moment, a bit of a pipe dream, really, isn't it, in terms of the performance of the New Zealand building industry. It's about consequences and having the ability to go after these people, but also making sure that the errant players aren't hiding their mistakes under non-disclosure agreements when they settle with owners.
Yeah, that multi-tiered structure seems appropriate too when you're trying to move more to a risk-based type arrangement, which seems to be one of the key things with even the way consenting's done and inspections. Higher risk projects need greater capability.
It's matching the right people with the right job. But of course, at the bottom end, and for residential builds, the government's proposing that they'll allow builders to build without building consent and potentially self-certify.
And I'm involved in numerous projects at the moment. One very large one where we're doing multiple buildings, and so we've just submitted the consent for the next building, and we're using very good architects, and we've got a lot of experience from the project to date, and yet we've still received a significant request for further information against this consent. And when I have a look through that, there's a whole lot of things in there I would have expected that the architect would have included, and council's picked that up. Now, that's been portrayed as council getting in the way of progress, but in fact, all they're picking up there is stuff that the architect should have put in the first place.
We have seen it for decades now, where that is exactly the problem, that it is not the council standing in the way, it's because the documentation that is provided to them is sorely inadequate.
Yeah, and we've seen examples where good packages of documentation go in and they get through the system just like that. Because council, I think, is playing a really, really important role to ensure that the quality of what's coming through is good. I can't see any motivation for them to be doing anything other than just making sure that the documentation is going to meet the requirements of the code.
Yeah.